So good afternoon. We have Wildrose Shadow Electricity and Renewables Minister Don McIntyre here. He'll be going quite extensively through the slide deck that you also have in your packages, and then we'll be happy to take questions at the end.
Good afternoon, everyone. Since the launch of a PPA termination lawsuit by the NDP government in July of this year, Wildrose has been busy piecing together the details available to determine when exactly this government was aware of the Article 4.3J, the change in law clause, in the power purchase arrangement. Just yesterday, in question period, the Premier refused to answer that question. Today, we're going to present what we know with a detailed timeline and urge the government to be forthcoming with documents that we believe will clearly prove the NDP have misled Albertans. The frivolous lawsuit launched by the NDP government against NMAX, a company owned by the City of Calgary, has no positive outcome for everyday Albertans. And with this new information we are bringing to light today, we seriously hope that they will see that the game is over, drop this expensive, frivolous lawsuit, and stop the cover-up of when ministers knew about this crucial clause in the PPA. I'm going to walk you through this timeline. You have copies of these things in your press kits, and then when we're done, I'll answer any questions you may have. So if you could just stay with me as I go through this. In June of 2015, an order in council was made amending the carbon tax contained within the specified gas emitters regulation. It was not brought to the legislature, it was just an order in council. Minister Phillips at that same time announced that Dr. Leach would be leading an advisory panel on climate change. Then in August, Minister Phillips announces that the members of the climate change, she announces the members of the climate change advisory panel chaired by Dr. Leach, as well as a public consultation dates and call for submissions. Then in 11th of September, the Balancing Pool releases a public report called The Impact of Greenhouse Gas Regulation Changes. And it showed that the changes to the Specified Gas Emitters Regulation, known as SEGR, may push some PPA costs above the expected pool prices, specifically highlighting the potential for termination under the change in law provision. The power companies were warning of PPA impacts. On the 18th of September, TransCanada sends its submission to Dr. Leach. They note that buyers could terminate if policies are implemented before the expiry of the PPAs. Depending on the timing of implementation, the impacted parties could be PPA buyers or asset owners. Following that, on the 30th of September 2015, Capital Power sends its submission to the Leach panel, including, again, a section on the potential for and consequences of PPA terminations. They outline the climate change plan and its consequences on their industry. On the 22nd of November, Premier Notley and Minister Phillips announced the Climate Leadership Plan, which is based on the advice of the advisory panel chaired by Dr. Leach. And the specified gas emitter regulation changes from June remained in place unchanged. On the 9th of December in 2015, NMAX notifies senior bureaucrats and political staff that they are considering termination of the Battle River 5 PPA under Article 4.3J. NMAX alleges in their court documents that they notified Grant Sprague, Deputy Minister of Energy, James Allen, Assistant Deputy Minister of Electricity Sustainable Energy, and a Senior Policy Advisor to the Minister of Energy. At that time, a briefing note was prepared in anticipation of the issue being raised by the opposition in question period. And that is an important note. I'll come back to that a little later on. NMAX, 2 days later, on December 11th, sends a letter to the Balancing Pool, clearly telling them what they had forewarned the government, that we are canceling or asking for cancellation of our PPA based on Section 4.3J. Now, as you can see in your kits that you've got, we have highlighted some of the juicier bits for you. Next slide then. On 27th of January, there's a letter from the Balancing Pool to NMAX confirming their termination of Battle River 5 PPA pursuant to Article 43J. This was a massively important permission that the Balancing Pool had granted to NMAX, recognizing that they had the right, not a privilege, but a contractual right to cancel the PPA, that indeed a significant event had taken place. There was a change in law, and NMAX is entitled to return their PPA. On 24th of February, the Balancing Pool releases a news release on that decision to allow NMAX Battle River 5 termination pursuant to Article 43J. This was not a secret document. On 7th of March, TransCanada gives notice. It will terminate Sheerness, Sundance A, Sundance B PPAs, again, pursuant to Article 43J. Eldon McIlwain, Chief of Staff to Deputy Minister of Energy, flags it for Evan Romano, Chief of Staff to Richard Discerny, the Deputy Minister of Executive Council, and indicates another briefing note will be written. We in the opposition asked questions on these PPAs, mentioning 43J specifically on March 10th, 16th, 17th, April 4th and 7th, May 9th, 10th, 16th, and June 1st. And during Bill 20 debate, the Environment Minister states that she read them all when referring to the submissions made to the Climate Change Panel. And these submissions are the ones that I just told you about from TransCanada and Capital that were made back in 2015, where they highlighted the significant impact that the carbon levy under Seeger was going to have on the PPAs. So if she really did read them all, then obviously she knew back in 2015 yet. Then we have the government filing suit. And here we have a statement in that filing that the present Minister of Energy, Minister of Environment and Parks, Attorney General only became aware of the August 2000 letter, and that's the letter that refers to 43J, after NMAX sought to abandon its obligations under the PPA. The concept of purported or more unprofitable amendment was not set out in written or verbal briefings from government officials from May 2015 to the first week of March 2016. This is part of their pleadings to the Court of Queen's Bench, where they say we didn't know a thing about this clause until we were told in March. That's a significant date and item right here. Following this, John Heaney files an affidavit. And in his affidavit, he makes a couple of interesting statements. I'm going to read them out. My work with Executive Council made me privy to all but a few in-person briefings of cabinet ministers and all senior officials that touched on PPAs and related issues, as well as to materials prepared for those briefings or otherwise describing or relating to PPAs. So it's pretty self-explanatory. Now, we go to our FOIP and new items. We've discovered that on December the 9th, 2015, later in the day after NMAX had notified those senior officials that they were going to be terminating their PPA, through FOIP we discovered that a briefing note was prepared by senior officials in preparation for question period that day. So the sequence of events is, in the morning of December 9th, NMAX makes a phone call. They talk to senior officials in the government saying, folks, because of what happened in Seeger, you've made a change in law, therefore it has triggered Section 43J. Immediately following that, like any good bunch of bureaucrats, they prepare a briefing document for the minister to go into QP with because of the obvious risk that somebody in the opposition, like me or someone else that's on this file, is going to ask a specific question about NMAX's cancellation of a $1 billion PPA. In this particular briefing document, it discussed PPA terminations specifically because of a change in law. How do we know that? The briefing note was prepared for James Allen, who was then ADM of Electricity, and the title of that briefing note is 1209, the date, 2015, potential PPA termination hyphen change in law briefing note, doc. Right there. And we have that in a FOIP. If there's a smoking gun, this is it. And that was on December the 9th. The government maintains we didn't know anything till the middle of March. I think we've all played the game Balderdash, right? So as we continue on here, that briefing note was sent to Minister McQuaig Boyd's Chief of Staff, an issues manager in the Premier's office, and 3 other senior officials. It was created and distributed on the same day, and it involved the same 2 senior civil servants NMAC states in their claim that they informed on the morning of December 9th. And the email chain went on to include 2 political officials and 8 senior civil servants. Graham Mitchell, Chief of Staff to the Minister of Energy, Brad LaFortune, Issues Manager in the Premier's office, Grant Sprague, Deputy Minister of Energy, Eldon McElwain, Chief of Staff to the Deputy Minister of Energy, James Allen, who was then Assistant Deputy Minister of Electricity and Sustainable Energy, Evan Romano, Chief of Staff to Richard Discerny, the head of all Deputy Ministers, David James, who is now Assistant Deputy Minister of Electricity and Sustainable Energy, but at the time was the Executive Director of Electricity Policy, Calvin Karabanek, Special Advisor, Wholesale Policy for Generation Transmission and Wholesale Branch in Energy, Andrew Buffin, Executive Director, Generation Transmission Branch, and Allison Hanson, Executive Advisor, Electricity and Sustainable Energy Division. So this entire argument of we didn't know now comes tumbling down, because on December the 9th, these officials were notified. The government would have us believe that a briefing note prepared by James Allen, the ADM, called this potential PPA termination change in law briefing note, somehow did not mention Article 43J change in law provision, even though that briefing note was prepared immediately following NMAX's call in the morning. And even though the NMAX December 11th letter, the formal notification of cancellation of the PPA, specifically mentions the more unprofitable language, and the government would have us believe they had no idea that clause was in the PPAs. So I'm calling on this Notley government to release the original briefing note, and let's just see. Did the title was not accurate? The government can and should publicly release the unedited briefing note, and the government's obvious mishandling of these PPAs is further evidence of their stubborn unwillingness to change direction when their socialist agenda brings obvious, real, and harmful consequences upon Alberta families. They made a change in law just after they came into power. They upped the carbon tax under Seeger. Now, if you take into consideration how much extra revenue they think they're going to get from that, and compare that to the cost of these PPAs coming back, the lost jobs in Hanna and Forestburg and Keep Hills, total up the entire cost of that silly move, any reasonable person would say, well, hold it, let's rewind, let's go back. I'm sorry, we shouldn't have done that. We didn't realize the consequences. But no, this government continues to double down on their mistakes. And they're forging ahead anyway, in spite of the consequences to real Albertans and future Albertans through the increased burden this is going to be on our taxpayers. I will take your questions now.
There was a provision in there, a change in law provision that would render contracts unprofitable. Companies could cancel PPAs. What makes you so certain that the more unprofitable is what the government was writing about in that briefing?
The more unprofitable phrase added into the eventual PPAs was not a secret phrase that was slotted in secretly. On that page of errata that contained that clause, there were, correct me if I'm wrong, I think 25 or 26 other errata included that were published and appended to that PPA document. It was completely circulated amongst all of the players who were involved in the whole PPA auction. This was not a secret thing. Everyone in industry knew about it. The balancing pool knew about it. The government knew about it. I know the government would have us believe this was some backroom secret deal that was done, but by no means was that true.
Of all the names on that list, none of them were the actual politicians, the energy minister, the environment minister, who said they weren't aware. Because this is an issue that's going to be in front of the courts, that could matter, because there's no proof that, and as likely as it may be, that, you know, these senior people in the offices of the environment and energy minister would tell the minister, how do you know for sure they did? Isn't it possible that they, A, didn't understand the importance of what they were seeing? It's fairly complicated, or B, didn't tell them.
All right, let's go there. If they received that briefing note and didn't understand it, they're still misleading us because they were in fact briefed on it, and they're claiming in their documents they weren't even briefed on it. That would be incompetence. Second, if they never received it, they somehow or another a briefing note prepared for question period, which is for the ministers, got to these 8 or 10 senior people and somehow didn't get the extra jump into the minister's hands, well, that again would be incompetence on the part of these people, and you know, their employment ought to be reconsidered. This was a very important billion-dollar issue. I find it impossible to buy the argument that it didn't get into the hands of any ministers at all. Second thing, third thing, in Mr. Heaney's affidavit, if we can get back to that affidavit from John Heaney, he makes a statement here. My work with Executive Council made me privy to all documents and related issues, as well as to materials prepared for briefings or otherwise describing or relating to PPAs. As a result, if a relevant cabinet minister or senior official in the Alberta government at any time before March 14th, 2016 knew about the August 2000 letter, I believe I would have known about it as well. Do you see what he's claiming? This is an affidavit filed with the court. He says, if there were briefing notes prepared because of my position, I would have been privy to it. Well, we have it. We even have the title of it. So I will take him at his word that he was privy to it.
But we don't know in that briefing if it mentions more unprofitable.
Actually, I have that briefing, and it doesn't. It's like, okay, so what it says is Deputy Minister of Executive Council came by on December 10. It says, it does talk about the change in law provision, which is the answer to the QP question, or possible QP question, but what it says is, and this is where the problem lies between the unprofitable and very unprofitable thing, it doesn't mention in here more unprofitable. All it does is mention unprofitable, which is something that they've agreed, you know, that was kind of known about. So it seems to me that the problem would be that the briefing notes prepared never mentioned more unprofitable. Or more unprofitable are those 3 words that are super duper important, right? It's not just unprofitable. And so when you have a briefing note prepared for government that fails to mention those 3 words, is that not just a really shitty briefing note?
You know, that may well be. However, the balancing pool in their news release from way back made it really clear why these things were being terminated. In NMAX's phone call, they made it clear, according to their own submissions to the court. They made it clear. So now it's a she said, he said issue.
Right, the briefing, I mean, because the letter from NMAX, it does say, and you're completely correct, it says Article 4.3J on the basis of change in law. It says in there unprofitable or more unprofitable. They do spell it out. But that message, that paragraph was never carried over to the briefing notes prepared for government. So that would indicate to me that it's not so much perhaps government saying what it knew when it knew that it didn't know something when it did, so much as 3 very important words were just never carried over to the briefing note for government, right? For Deputy Minister of Executive Council. And they're 3 very important words that for some reason were missed in preparing that briefing note.
I agree with you. Those are 3 very important words. However, that said, if the minister of this file, and there's more than one minister following this file, as you may have followed things along, we have the Minister of Energy, we have the Minister of Environment mostly, and we also have the Deputy Premier mostly. And we have a significant number of senior officials here who knew full well about the or more unprofitable. It was not uncommon knowledge throughout the industry, and those officials that are on that list are people who've been enmeshed in this whole electricity file for years. This is not new news to anyone in the industry or in the bureaucracy. So in the discussions that they're having us believe that in all of the discussions that they would have had regarding this, nobody mentioned or more unprofitable. I don't buy that argument.
And that is what government says, right?
Sure it is. So they're either incompetent on a scale that is profound, or their bureaucrats are incompetent on a scale that is profound, or someone's lying.
We'll take a final question.
Really? Only one more? This is so huge. But on that point, no matter who, I want to ask you this. So government argues that the reason that they are taking this to court is because the all more unprofitable thing was inserted secretly against the rule of law and no one had the jurisdiction to do that. Now bear with me here.
Sure.
So if that's what government is arguing, it actually doesn't matter whether John Heaney knew about this in December 11 or whether he knew about it on March 14, because government argues that the whole entire contract should be invalid because of this last minute bargaining chip of all more unprofitable being thrown into the PPAs, right? So does it even matter when he knew about it?
Well, it does.
Materially, I know what you're saying, like, you know, you can't be lying, but materially, it doesn't seem to really matter to the government's case.
The government would like to believe that it doesn't matter to the case. The or more unprofitable phrase was one correction on a long list of errata. So if we're going to say that, well, that shouldn't have happened, then that means the whole entire other 25 or 26 items on that errata are also invalid.
But they argue that the other ones in the errata are things like calculations, which are you know,
Very important.
super important. But this or more unprofitable, they argue, changed the entire meaning of the entire PPAs, whereas those calculations were fundamental to the PPAs.
Price Waterhouse disagrees with that statement. The independent assessment panel who were reviewing this whole auction and its setup, there was two. There was Price Waterhouse, and I'm sorry, I forget the name of the other one. These were the experts that were overseeing and looking at the entire creation of the PPA agreement itself, as well as how the auction was, the deregulated auction was going to operate. They made it very clear in their submission on that particular point that that was the government's intention all along, that it be unprofitable or more unprofitable. And they specifically said that in their submission, that it was the government's intention all along that or more unprofitable be understood in that PPA in 43J. And they agreed that, yes, maybe we should make it even clearer. Let's insert that phrase. This was not some secret backroom swindle. It was, according to the independent body, it was the intention all along.
So to clarify, the government either knew, or it's lying, or it's gross incompetence by bureaucrats.
Or a combination of all three.
Okay, thanks, everyone. If you have any technical questions, just feel free to send them as well, and we can